Welcome to the Best Florida Family Law Podcast, brought to you by Jacobs Law Firm. My name is Attorney Jonathan Jacobs, and we are so glad to have you with us here today. Is mediation mandatory in Florida family law? Is it mandatory in a divorce case? Is it mandatory in a paternity case? The answer is maybe. Most counties where I have litigated, all the way in Central Florida from coast to coast, require mediation. Mediation is generally not bypassed unless somebody makes a motion asking the court to dispense with it. Why is mediation a requirement in most counties before you can proceed with trial? That is the ultimate $50,000 question. Let's try to answer it. Let's think about public policy considerations. Let's think about the value of mediation. Let's think about what mediation can accomplish for you and the other party. Let's start with a paternity case. Suppose that both parties, both parents, have been unable to reach an agreement on a parenting plan, and therefore they cannot properly calculate child support. Maybe they do not even agree on each other's actual income when calculating and factoring in health insurance, daycare and or aftercare for after-school expenses, and calculating in any reimbursed expenses, factoring in overtime, bonuses, commissions, and other sources of income. What then can they agree upon? Well, once you go to mediation, providing both sides have enough information to make informed and intelligent decisions and perhaps come up with an agreement that is mutually satisfying to the extent anything in a family law case can be satisfying. Let's face it, people do not often walk away from family cases thrilled and happy and jumping for joy. These are deadly serious issues that involve family. Nothing could be more important and more serious. To that effect, suppose that two people are at mediation. They have not been able to agree to a parenting plan, even with the help of two capable attorneys who enjoy settling cases because they believe it is a good thing when the parties can agree. And perhaps that it is generally, not in every case, but generally, in kids' best interests, in parents' best interests, and perhaps even in a sense, in the best interests of the courts and the attorneys. At mediation, a neutral third-party mediator, who you do not know presumably, who is not the judge in your case, who is a person appointed by a person that has been authorized by the Florida Supreme Court to conduct mediations in family law. They have been thoroughly trained, thoroughly educated, and then some. This person will be responsible for trying to help both sides reach an agreement. Let's take a quick step back. It is often said that mediation is a voluntary process. Well, then why the heck? Of course, we're keeping this PG-13 at max. I do not wish to have an explicit rating. Thank you very much. Especially since this is technically a family law program. Why on earth do the parties have to attend mediation if it's a voluntary process? While your attendance may be mandatory, your participation is not. That is why it is called a voluntary process. While most courts require you to go to mediation, public or private, a distinction we will make at a future time, they do not require you to stay. You can attend mediation, say hi to the mediator, say bye to the mediator, who must record you as having been present. You reach a non-agreement and you leave. That is the height of foolishness in almost every case. It is the height of foolishness because mediation is your opportunity. Mediation is your midpoint of the case. Mediation is your time to try to settle. Or at a minimum, try to understand the other person's perspective on what they are looking for. Maybe find out if there's any room for getting closer to a settlement, because not everybody wants to go to trial. Not everybody wants their case to continue to be litigated. Most people want their case to be concluded in a reasonable time. Family law cases notoriously take a long time to conclude, and therefore If you can resolve your case in a reasonable time, and preferably at mediation, on terms that are mutually agreeable, even if not perfect for you both, the idea is compromise after all. You must not, or I should say you cannot win on every single issue and possibly hope the other side to come up with an agreement with you when you give them nothing and you compromise nothing. And instead, you simply have them take all of the hits, as it were, proverbially speaking. The idea is that both sides will walk away with an agreement that is in the best interest of their child or children. Not just their own best interest, but the best interest of the kids. That is the prevailing standard in the state of Florida. It is a public policy that both parents have continuous and meaningful time sharing with their minor children. In fact, the Florida legislature has incorporated a presumption of 50-50 equal time sharing for parents. It is not the mediator's job, however, to come up with an agreement for you. The mediator is not supposed to give you legal advice. The mediator's job is to go back and forth, side to side, present each party's requests, try to narrow things down to agreements on each individual issue, and come up with a framework for a parenting plan, if this is paternity, and a child support guidelines-based agreement after we know the number of overnights and the amount of time sharing. Quickly, if this is about divorce, dissolution of marriage in Florida, what is the difference? Mediation will probably take, if successful, based upon experience, a substantially longer time, 6 to 8 hours, maybe even 2 mediation sessions, because not only are you deciding time sharing in a parenting plan, not only are you deciding child support, you may be deciding issues such as the distribution of your marital assets and liabilities and alimony. Now, that is an awful lot to decide in one day or in a 3 to 4 hour time window. A successful mediation might take all day or multiple sessions. It entirely depends on the willingness of the parties to compromise, the willingness of the parties to meet closer to the middle. These cases are inherently polarizing. That does not mean that it should cause your negotiations to fail or to be anything but in good faith. Mediation is mandatory in a vast majority of courts where I've litigated. Even if it were not, mediation may be a good idea, especially if you find a great mediator, especially if both attorneys believe that there may be room for agreement, there may be room for settlement. It can help you. If your case ends at mediation, then perhaps your case will resolve all issues, not require a trial, save these folks, you, the parents, you, the spouses, money and time, aggravation and heartache. Mediation can be a great thing when successful. Thank you so much for listening to the best Florida Family Law podcast brought to you by Jacobs Law Firm. None of this has been legal advice. Our show is intended to be informative. It does not create an attorney-client relationship between us. We hope that this has been great for reference and that you will go ahead and learn more about the process. Please feel free to call our firm at any time. We'll be glad to speak with you. Thank you so much.